thank you so much for joining us today. We're going to get into the depths of legacy planning, which is a very big topic, and it's different for everybody that we serve. My name's Rheaume. I'm a certified kingdom advisor, so I have a very much a biblical passion to help people with stewardship and financing, or just with their resources in general. Daren, I'll turn it over to you just to give a brief introduction, and we'll talk a little bit about FEG as a company, and then we'll get into the meat of our topic today.
Yeah. So my name is Daren Hardesty. I'm a certified financial planner. I'm in the middle of my 6th year with FEG. When I came into the company, I had spent almost 13 years as a public educator. I was an elementary teacher and high school teacher, baseball coach. So I had pretty much a full career as an educator before I came over to Financial Enhancement Group. How I got to estate planning and why I really enjoy this part of what we do is primarily because of our managing partner, Joe Clark. This is his passion, estate planning, and I got to work with, and still do. I get to work very closely with Joe and a lot of the families that he takes care of at FEG. And so every Joe meeting, we're going to talk estate planning. So I just got a really quick education in the basics, and since then, I've just kind of become the more accessible estate planning expert, if you will, on the team. So full disclosure, Aaron and I are not attorneys. So there's anything that we provide to you today is not considered legal advice. We're coming from the perspective of a financial planner who sees the full picture from the beginning of the story all the way to the end of the story. Like we like to say, is that we want to help everybody complete their financial journey, and estate planning is the last chapter of that book. So we want to make sure that we have enough expertise and guidance to get you guys moving in a good direction.
Awesome. Great. Thank you, Daren. And yeah, Daren and I have worked together for the last 6 years, and he does have an extensive knowledge in the estate planning side. So he's a great addition to our team and also a partner here at FEG as well. In full disclosure, FEG, Financial Enhancement Group, we are an SEC registered investment advisor, which means we manage more than $100 million in assets. We're not endorsed or guaranteed by the SEC. We are registered with them. We have families in over 30 states and take care of a little over 1,200 families in those 30 states. We've been an independent company for the last 28 years. We have 4 offices here in central Indiana, and then we have advisors also spread in a couple different states, such as California and Georgia. So we've done this workshop series. This is the 3rd or 4th workshop that we've done this year. Our upcoming workshops you can see on the screen. In August, we're going to talk about investing and having alignment with biblical principles. September, and really the last quarter of what we do at FEG, at the Financial Enhancement Group, is tax planning. And so tax planning revolves around so many different aspects of our family's lives. It comes into play in estate planning. It comes into play in just normal financial planning. So we spend the last quarter of the year really educating our families on making sure we're tax efficient with the type of planning that we're doing. And so you can see on the screen there, those are the next workshops that we'll be doing. Today, as I mentioned, we're going to get in depth on legacy planning. We're going to get you probably I would say maybe a bachelor's or associate's level degree in legacy planning in about 45 minutes today. We're going to cover a lot of topics. They'll be in depth, but what I want you to understand is if you have questions, if there's things that Daren talks about today as we walk through this, please send those to the chat. That way we can answer those. If it's something that we can answer in live, we will. If not, we'll save some time at the end to answer those questions. And more importantly, if what we talk about today really sparks an idea or a question, you can reach out to us and we'll leave our information at the end of this. We're going to throw up a survey, and the first question is, how confident do you currently feel about your family's legacy plan? You can be very confident to maybe there's some specific things that you have questions about, or you have no idea about the legacy planning in general. Are those poll numbers coming in, Tarna?
We have 19 so far. We're about 73% participated. Let's get those last few in. Daren and Aaron, you got to participate too, gentlemen.
I'm very confident.
And I just clicked neutral to get it off my screen. So as a planner, I am very confident in my legacy plan. I have a trust and everything set up. So I just clicked neutral.
Wonderful. Is it completely funded? Just kidding. And the poll results.
Darren's my planner, so we got to work on that.
That's right.
You should be seeing the results on the screen now.
Yeah. Maybe I clicked off from it. So.
All right. Well, we've got 11% very confident, 37% somewhat confident, 26% neutral, 26% not confident at all. No one has specific questions that they're wondering about yet.
Perfect.
Let's change that.
Well, it's a wide range, right? So we've got about 38% that feel very confident, and we've got some folks that need some questions answered. So wonderful. I'm gonna move on along. Let me scroll back here. Prior question is, this is where Daren's going to take over, is we're really going to define what legacy planning is. So Daren, I'm going to hand it over to you to run with your part of the presentation, and then I'll step back in when I'm needed.
Sounds good. Thank you, Aaron. So we at FEG, we focus heavily, we call it legacy planning. You might hear it called estate planning in other firms. And technically, for the majority of what we're doing, it is very much the same. Estate planning and legacy planning are very, very similar. Estate planning is tied primarily to the legal documents that you have executed for your estate. So they're the requirements that people like Aaron and I are not qualified to write documents or do those types of things, but legacy planning, where it is different, is that it's more relational. It's more into the specifics of your personal situation and making sure that your estate plan, all the documents, are in alignment with those personal wishes that you have for your heirs. And it's very similar, but when you hear legacy, it's really important that you understand that this is a personal journey that everybody who's wanting to be proactive with their estate plan, we are here to help kind of guide you through some of those questions that are just as important to you as what the attorney may say is important as far as the correct provision that's drafted into your documents. So that's why we call it legacy planning, because we, like everything we do at Financial Enhancement Group, it's catered to the individual family. There might be similarities family to family, but in the end, we want it to be personal for you. And so as we go through today, we're going to kind of key in on some of those more personal things throughout the presentation to kind of show where that differs from just a standard estate plan. But yeah, legacy planning is very personal. It's what matters to you and to your family. So if we want to move on, Aaron, to our first topic that's tied to this that we're going to cover, it is going to be protecting your assets and your family. So what does that mean? Which assets, in this question, which assets do you feel are most uncertain about properly titling or protecting? So when we're looking here, we have homes, property, real estate in general. You have your personal belongings, other assets that you have, essentially things that are under your roof. So, the picture of the diamond ring there. So jewelry, family heirlooms may or may not have actual monetary value, but they may have a lot of sentimental or family value. Then you have investments. So investments come in all shapes and sizes. They could be IRA assets, that from a 401k through your work, Roth IRAs, brokerage accounts, any type of investment that you currently own. Those are all types of things that we want to make sure that we are protecting our family and yourself. So outside of that, how do we build and start to make sure that your plan has as few friction points along the way as possible? So, avoiding these unnecessary, complex and stressful things. And notice that word there at the end, probate. One thing at a minimum that we want to make sure that people understand today, to have a really good or a above average estate plan, is that you have a plan that is going to avoid the probate process. Attorneys love probate. Estate planning attorneys, even the best estate planning attorneys who want to help you build an estate plan and be proactive with your estate plan, they still make the vast majority of their revenue from probate, just because the majority of Americans don't do what you guys are doing and try to look into this stuff and be proactive about what they're building. And typically what happens is that people die, and the state that you live in will kind of help dictate your will to tell the probate process what needs to happen. It's very expensive. It's time consuming for your heirs. And it's at this point, it's unnecessary. It's not something that you have to go through. The way that probate works, just as a quick rundown, is that your will is in place to capture what's called your residual estate. And all that means is that, hey, everything that did not have a beneficiary attached to it, everything that was not owned by a trust, it becomes a part of your residual estate. In the state of Indiana, if your residual estate is over $100,000, your estate is required to go through probate for those assets. Attorneys take on average somewhere between 2 to 4% of whatever value goes through probate. So it's a large tax, if you will, on the back end that you can avoid. And it's not to mention the amount of time and stress it takes to complete that process. So we want to make sure that you understand, how do we avoid that? That's kind of the beginning phases. That's estate planning 101, avoid probate. The second thing is making sure that your assets and how you pass them to your heirs is in alignment with your values. It's in alignment with what you feel is best. It's in a way that you can potentially mitigate a certain level of risk, even when you're gone, for how those assets go to your beneficiaries. And there's all types of reasons for why. At FEG, we're very blessed. We take care of a really good group of people. Typically, the families we take care of, they trust their kids. They feel like their kids are doing well. They're smart. They have got everything under control. They're not worried about them financially. But there's still risks involved by receiving what's called a lump sum inheritance from your parents. Depending on the value of the assets, that risk can only get greater and greater. And so we want to make sure that you understand what those risks are, and make sure that you're in alignment with that. So just a short story. In my family, one of my wife, her grandmother passed away, and she did a great job. Her and her husband did a great job, put everything into a trust, and everything was good to go. But there was one bank account. And at the time, the rule of Indiana, you had to have your residual estate only had to be $50,000. Well, she had one bank account that was outside of her trust, and everything avoided probate except that one bank account. It took 9 months for my mother-in-law and her brother to clear all of that up over one small piece of her estate. And so it's one of those where you're going to make sure you have everything in line. From that, just kind of, we're going to get into more of the details here, but just it's important that you know that probate is not fun. It's not something you have to worry about, unless you have a parent or family member that you are responsible for their estate. But typically it's going to be your kids or somebody that's going to have to make sure that that's all cleaned up. So we want to make sure
Hey,
you
Daren.
understand how we do that. Go ahead, Aaron.
Real quick before we bounce into the responsibilities of the trustee, here in the state of Indiana, can you just give kind of, and maybe you mentioned this, but just the cost of probate? I know you mentioned the length of time for your grandmother or your wife's grandmother. It took 9 months, but can you give an idea of general cost perspective as well?
Absolutely. So from what we have found, on average, attorneys' fees are generally anywhere of 2 to 4% of whatever the asset is that goes through probate. So the more money that comes through, the larger that 2 to 4% becomes. I don't want to speak ill of attorneys. We have a lot of really great attorneys that we work with, but I don't know if it's a matter of them not knowing what they don't know, which is to be expected. They're not looking at it from our perspective. But I can tell you that, if I was to go into a law office today and tell them that I wanted a trust, they would tell me, we'll build a trust into your will. It's called a testamentary trust or a springing trust. And what it does is essentially allows the attorney to still take my estate through probate. And where I'm at in life today, I'm worth much more dead than alive through life insurance. That won't always be the case, I hope, but today that's the case. They would look at me and say, I can't make that much money off of this guy giving him an estate plan. But today, if I give him a trust today, I'm going to pay him $3,000 for my estate documents, and I'm going to get that's $3,000. But if I die and my estate has to go through probate, they're going to get a much larger check to service my estate through probate. And from their perspective, it's from the way they look at it, it's, well, I put a good plan together. Everything's in good order. We're taking care of the kids. We're making sure everything ends up in a trust, but they still benefit a little bit more on the back end. So that 2 to 4% in that 9-month period, that's pretty standard. I have seen estates, larger estates, one that took 3 years to complete probate. It was for a family that owned a large restaurant chain, and they had a very large estate. Most of the estate value was in the stock of the company that they owned, and they never got around to putting that into their trust. They had a trust created, but they didn't get it into the trust in time. And the attorneys just took their time because of, it's just so complex, and it's going to take time, and it's going to take years to complete this, where I don't know what bill was paid, but I know it was a very hefty bill to get that completed. So for most of us on the screen, I think, what you should expect is that, get an idea of what 2 to 4% of your estate is, compare that to $3,000 for what most attorneys are going to charge for estate documents. And I can almost guarantee that the cost is more effective on the front end versus waiting and letting the attorneys calculate the bill on the back end.
Hey, Daren, someone just sent in a question directly to me, and they asked, is the same attorney that does my estate plan, are they also who will take care of my probate if I need it?
Most likely, because what happens is, kids, you pass away, and some of you may have gone through this with your parents. They pass away, you start looking for things. Some parents do a great job of saying, hey, if something happens to me, everything's in the top, it's in a folder in the top shelf of the drawer at my desk, and they know exactly where to go, or it's in the safe and they know where to go. And when they look at the will or they look at their documents, they're going to see an attorney's name and contact information. And it just makes sense. They're going to say, well, I'm going to call that person because they're the ones that drafted everything and they know the most about it. So they typically end up working with that person. But you don't have to work with that attorney if you don't want to. If you have a relationship with another attorney that you feel better about, you can always have them take you through the probate process. But typically it's the one that drafted it, simply because their name's right there on the document. It's easy for a family to reach out.
One other quick thing, Rita just mentioned, it's my understanding that in Indiana, a trust can be written by individuals and does not require an attorney. That is true in a sense, but I'll let you elaborate on that.
Yeah, well, I mean, you can definitely write your own will, but there is in today's world too. I mean, with AI and its ability to create things, it's much easier to do something like that on your own than what it was in the past. I would not recommend it. The last thing you want is to have a trust get contested and then find out that it didn't have the right provisions and the right statutes from the state written in there that are always required to be there. And just kind of go back to the legacy versus estate. Something that Joe Clark has said and that I think is very true is that, generally 80 to 85% of your trust document or any of your legal documents, about 80 to 85% of them are the same no matter who has that document. The differences lie in how the attorney drafts the documents, but the information in general is pretty much the same because they're all Indiana statutes or whatever the state is that the trust is drafted. But that 15 to 20%, that's where the legacy planning comes in. That's the part that's individual to you. That's the part that's not going to be the same in somebody else's document. That's where we really want to focus today, is on those things. So yes, I think, again, I'm not an attorney, I think you could write your own trust. There's companies like Trust and Will that allow people to essentially go on, answer certain questions, and that Trust and Will create the document for you where you never meet with an attorney. We have a platform at Financial Enhancement Group that does something very similar for our families that we take care of. But I would always recommend, if anybody was just asking me just randomly on the street, can I write my own trust? I would say, yeah, but I don't recommend it. I would work with an attorney or work with a platform that can do it for you so that you don't end up in a situation that's worse off.
Yeah, and I agree with that, Daren, too. The other complexity to it is writing that document, for one, is making sure it's following the provisions and things with state law. But the other thing is, if that were to happen, you still need the legality purpose of making sure that that document's witnessed, notarized, to make it formal and legal.
Absolutely. Yeah, absolutely.
Um, we're going to bounce to the next topic just because this leads into what you're talking about. And so we're going to talk about trustee responsibilities.
Yeah.
Um, and
So,
I'll turn it over.
yeah, thank you, Aaron. So trustee responsibilities, in Indiana, this is just anecdotal evidence here. This is just from our experience. And again, we are very lucky to work with the families that we take care of here at FEG. We know they're not the full population, but in general, what we see in central Indiana is that when people think, who should be in charge of my trust when I can't do it anymore, um, that typically ends up being one or multiple kids, your children. You trust them, you feel like they know what they're doing, they may have experience with this stuff. And so we see a lot of that where kids are given this responsibility. We have actually started a sister company that can actually serve as a trustee for trusts, where we're essentially a corporate trustee, where you're hiring a third party to oversee these responsibilities. But there are definitely depending on the situation, there's a good amount of work that has to be done year by year, depending on what your trust lays out. So, when you're preparing your family to be a trustee, these are things that it would be in your best interest to talk to whoever you name as your trustee to make sure that they understand what you're signing them up for. So the trustees' roles. So if you are the acting trustee, we're at the point now where when you create your own trust, you and your spouse typically are going to be co-trustees, the acting trustees for that trust while you're alive. You need that for a revocable living trust. And what that does essentially is that nothing changes about how you live your life and the things that you can or cannot do when the grantors, the people creating the trust, are also the trustees. Nothing really changes. There's no tax rules that change or anything like that you have to be worried about. It's just a titling issue where now you are no longer on the title of the property. Your trust is, but you're listed as the person responsible for the trust, the trustee, and you handle everything the same way. So at the point that you can't do that anymore, that's where you have what's called a successor trustee who steps in to carry out these responsibilities. And looks like we lost our screen, but we can keep going here. So the trustee's roles, essentially the trustee is responsible for carrying out the wishes of the grantors. Whatever the trust says to do, it's the trustee's job to act in a fiduciary fashion to oversee whatever those rules are. Um, those rules could vary, but typically as a successor trustee, it means that you're responsible for communicating with the beneficiaries, making sure that you reach out and say, hey, I'm in charge. Here's my game plan. Here's a timeline, making sure that they're aware of what's happening and it's not being kept from them. You want to make sure they understand that there's what's called trust accounting that has to be taken care of every year. Trust accounting is essentially just keeping track of all the money that's come into the account, all the money that's left the account for distribution purposes or paying expenses, paying taxes, those types of things. You have to keep track of those things that are coming in or leaving the account. If there's a house that's sold, you have to show in the trust accounting that, hey, the house here, it's worth $300,000 today, and it's held as a hard asset. You have to show documentation and when the house is sold and how that money, after all expenses are paid, becomes liquid and becomes investable. I mean, there's lots of things on that trust accounting that has to be maintained. And in most states, it's required by law that at least once a year, that trust accounting is shared with all the beneficiaries. It's just a transparency thing. Making sure that, hey, the people that aren't in charge, they know that, hey, this is being well managed. Remember, trusts are private. They are not public documents. If you have a trust, it is a private document, and only the people who are granted access to see that trust have any kind of look into it. So if I'm a beneficiary and my big brother is the trustee and he's not sharing anything, and I notice he's driving a new Corvette and I haven't received anything, that's a reason that I could say, hey, I'm contesting this, like something's not right here. And so a good trustee is always going to make sure that all of that stuff is shared and tracked and maintained to make sure that everything is transparent and everything's following the rules and you can stay out of court. We don't want anybody going to court. So if you're naming a family member, kind of helping them understand that concept of like, hey, I'm giving you a job. I trust you to carry this job out. The problem is kids, when they take over, that a lot of times they're in one of the busiest phases of life. I mean, they could have kids that are still in high school or college. They're, towards the back half of their career where they're probably, they have more responsibilities in their job. And you're just adding another layer of work for them that they may be willing to do, but it's important they know how much work it is. Talk to your trustee if you name one of your kids, or if you name a friend, or if you name somebody else. Make sure you let them know in advance, just to say, hey, just so you know, you're my trustee. I want to make sure you're aware of it. Provide them with a roadmap of what the trust lays out. Just gonna let them know, hey, this is how I want things to go, just so they have a general idea. Let them know if there's any issues, like these triggers, like different events. Make sure they understand, like, hey, I've got one son that, he's not really good with money, and he may have some addiction issues, or he has gambling issues, different things where it's like, please make sure you take care of him and don't hurt him. The documentation side, again, that's just, more is better, making sure that you're constantly providing the family with information as things progress. And then just regular check-ins as a trustee, just checking in with the beneficiaries and making sure that everybody knows, hey, what's different in life? What do we need to consider here? Here's a story too, that, when you have somebody that doesn't understand taxes, doesn't understand investing, but they're probably, other than that, they're a pretty good trustee, they're reliable. One thing that we've seen, this happened years and years ago, but one of our families passed away. Kids inherited the money. The money came from IRA accounts. The money came from a trust account. So they had, on the statement, it all looked the same. The dollar amounts. It's like, hey, we got $500,000 in this account. We got $500,000 in this account. It means no different to them. In their mind, it's all the same. Well, the kids did, really quick. They decided, hey, this is great. Let's pay off our house. And so they immediately went and they took money out of the IRA to pay off their house. Don't know why, but they just decided, well, let's do the IRA. Let's get that one taken care of. Well, when they did that, now that 200 grand that they took out to pay off their house, they got taxed at like ordinary income on that entire $200,000. Now, they had this other account sitting there from the trust that was not the same as an IRA. If they had a good trustee, the trustee, when they hear that distribution request, is going to say, well, you could take it from this account, but it's going to cost you a bunch of money in taxes, or you could take it from this one, it's going to cost you nothing in taxes. We're not going to stop you from paying off the house, but we want to make sure that you're making a good financial decision here and that it makes sense for your situation. And so those types of things come into play where having a good corporate or third-party trustee that understands that stuff, or any trustee that understands that stuff, you can really avoid some of those mistakes that can happen that was done for a good reason. I think most of you would say, yeah, I would love my kids to pay off their house with the inheritance. I have no problem with that. But it was not as efficient as it could have been. It cost the family more, and you can't take it back. So that's the kind of stuff that a good trustee is going to have a good understanding of those things and make sure that they're guiding the beneficiaries. They're not necessarily denying them of things, but they're making sure they understand that stuff. It's important because the IRS is counting on people not knowing the rules. Trust me, they don't want you to know the rules because in the end, it generally benefits them more when you don't have a clear understanding. So trustees a big responsibility. These are just a few of the things that they need to be prepared for, but the big message is whoever you name, make sure that they're aware in advance, that they know what the game plan is. Anytime you change your trust or make updates to your trust, keep them in the loop and just help them understand what's coming so that they can do the best job that they possibly can.
Hey, Daren, this certainly is a topic of hot consideration. There's a number of items in the chat. If you want to open up the chat, because some of them I think kind of correlate to one another. Sandy and Rita have a few different questions, and Dave C has also added one.
Okay.
But this is pretty normal. This is where a lot of the questions around a trust and trustees and when it actually happens, what happens.
Can you see it on the screen? And
then the little nuances that can come in, even Sandy, with you saying, I thought my IRA didn't need to be in a trust. So Daren,
absolutely. Yep. I'm going to start with Rita's question there. It says, can money be left to a trustee in the trust? Yes. We don't advise a beneficiary also being a trustee. Even in the best situations, let's say you have 3 kids. I'm going to use my family as an example. If I could name one of my kids as my trustee, it would be my son. He's my oldest. He's clearly the rule follower. I would choose him. Now he's 9, so he wouldn't really be. But yes, you can. But the problem is, if a trustee is also a beneficiary, that trustee has a lot of authority. And let's say you lay out a plan to say, you know what, I'd like you guys to receive this money instead of all at once. I'd like you to kind of receive it over a 5 or 10 year period, just to kind of phase into the money so you're not making mistakes and it's kind of protecting some of the money in the trust. Well, if Big Brother gets with his siblings and says, yeah, the trust says that we have to wait 10 years. I don't know about you guys, but I could use all this money right now. How do you feel about that? And the kid and the siblings say, yeah, it sounds good to me. And Big Brother's like, I really appreciate that. I didn't want to have to do this for 10 years. This just makes it easier. And together they make a decision to completely break the rules of your trust. And there's nobody that's going to challenge them. I mean, if they're receiving everything, there's nobody that can stop them. So that's a more realistic situation, but also, just when you're in that position, if you're a trustee and beneficiary, you kind of you have a conflict of interest that could be mitigated. So yes, they can, happens all the time, but it's just something that we don't recommend. Sandy, I see your question here. You said, I have an irrevocable land trust where I get the income. Are there any annual paperwork to do for this trust? Presently, I do nothing. Technically, Sandy, I guess I would, if you are the grantor of that trust, then technically you probably should, and ideally you have a CPA that can kind of make sure that that money is reported properly. If you are the income beneficiary of this trust, meaning that it would belong to your parents, let's say, and they left it to you, but it remains in that irrevocable trust and you collect that income, the trustee technically is supposed to report that income that's produced within that trust. Irrevocable trust, not to get too far into the weeds, but when it comes to reporting income and who's responsible, it comes down to the tax ID number that's associated with the trust.
Yep.
So for most revocable trusts, for all revocable trusts, the tax ID number that you report is your social security number. So everything just kind of flows through to your tax return. That's why nothing really changes. It just all flows through. For an irrevocable trust, most times irrevocable trusts have their own separate tax ID number, which means that their income has to be reported through a separate tax return. And typically what that means is that as long as that income does not land in the trust and held by the trust, then the trust doesn't have to pay taxes on it. If that income comes to the trust and the trust distributes that income out to the beneficiary is responsible for paying the taxes on that income. There's a K-1 distribution form. It's like a 1099, but a K-1 is how trusts taxes are reported when money's been distributed. So I would, maybe Sandy, we can maybe have a more detailed conversation about your situation so we can give you some good guidance there, but it just depends, I guess, is the best way to answer that. Sandy also said, does an adult child need to be compensated for being a trustee? How much? Most trust documents, that 80%, 80 to 85% generally will say that a trustee has the right to a reasonable fee. It doesn't say how much, it just says a reasonable fee. One of the benefits of naming kids as a trustee is that they're typically not going to take a fee. They might reimburse themselves for expenses that maybe they had to pay for doing the trust, but they're generally not going to take a fee, even though they have the right to do so. So most trust languages, when they talks about trustees, a reasonable fee is the phrasing that you see. So what is reasonable? That's up for interpretation. Some beneficiaries might say a larger percentage than others. So it's just one of those where, not knowing what that is, or if they're actually going to use it, that's really up to the trustees. It's in their discretion. I don't know about you guys though, but it's hard to determine what your time is worth. And so most trustees, if it's a kid, they're going to say, I don't know, is $1,000 too much? I'm not sure, so they end up not doing it. So that is a financial benefit of having a kid, is that they're generally not going to take extra expenses from the trust. Corporate trustees will take a fee. They'll have a fee schedule, follow that fee schedule, and they will take that fee. I can tell you that trust companies that manage trusts, their fees could be all over the map. A lot of them base it off of net worth. A lower fee based off your entire net worth. Some will say that it's based off of the assets that they have under management, a percentage of some kind. And so it varies. At FEG Trust Services, we try to make it as fair as possible and break those fees out based off the types of assets you have, the amount of work it takes, et cetera, so that fee is reasonable according to the trust. What are the advantages and disadvantages of having a trust as a placeholder and using TOD, POD, and the transfer on death deeds, investment beneficiary to fund the trust upon my death? It's mostly a friction point. You're absolutely right. You can name your trust as a beneficiary of your accounts, bank accounts on your home, but it's adding an extra step. And in this world, things move slow. And so, if you can avoid that extra step, it just speeds the transfer of assets up. It speeds the process up. And so from my perspective, unless there's a circumstance that says, hey, this makes more sense to do it this way, I always typically say, go ahead and fund or put everything in the trust that should be while you're alive, because it will speed the process up when the successor trustee takes over. It's just less work on the back end. Plus those documents, like a transfer on death deed on a house or a property, that costs money. And it's just going to be an additional expense on top of what you've already paid for the trust documents. So you can do it that way. Sometimes it makes sense, but most of the time I'd say that makes just as much sense to get it done while you're alive. It's not going to take any of your powers away. As the trustee or as the owner of the asset, everything stays the same. So there's really no immediate need for it unless the circumstance calls for it. Last question. Well, I'll do one more question here. It's my understanding you don't need to put an IRA in a trust, true or not? Well, you can. You can't title your IRA to your trust because a trust is an individual retirement arrangement or account. It's individual. It needs to be a living person that owns that IRA. You can make your trust the beneficiary of your IRA, but you really have to be careful about the documents that you had created to make sure that the trust is what's called a conduit trust, a legal term there. And what that means is that the trust needs to have up-to-date language for how IRAs or qualified accounts are treated after you pass on. You need to make sure that language is up to date, and you need to make sure your attorney understands that so that it's in there, because while it may all work out just fine, if things aren't written properly, you put the trustee in a really tough spot. You could put the IRA accounts under what's called a 5-year rule instead of a 10-year rule for inherited IRAs, where the trust has to distribute the assets over 5 years rather than 10. But if it's written properly, you can have an IRA land inside of a trust. Now, as a person who administers trusts, I would much rather that not happen, because the liability is on the trustee to make sure that they understand those rules and that they carry them out properly, that they account for them properly. There's just a lot of things that could go wrong that I would rather you avoid. What we know, though, is that most people with wealth. Go ahead, Aaron.
The income distribution.
Yeah, the income distribution. It's hard. You're putting the trustee in a tough spot if the IRA lands in the trust. And what I know is that most attorneys, because they don't do what I do on a daily basis as a financial planner, they don't know the rules of IRAs the way that I do. And so from their perspective, yeah, just have it go to the trust. Everything's great. And they probably feel like they're right. But you know the difference. When I read a trust that has good qualified retirement account language, it is great. It's like, okay, they clearly understand how this should be treated. It gives guidance to the trustee. Things should work out fine. But a lot of trusts just don't. They just don't. And it's nothing against the attorney. It's just not all documents are created equal. The worst case scenario that I could see, and I know that Joe has seen this in the past, I think it was a Fidelity situation. I could be wrong, so don't quote me on that. But years ago, somebody left their trust or their IRA to their trust. The custodian has their set of rules, and that would be in this case Fidelity. The attorney has their set of rules and the documents. The trustee has their way of interpreting all these things. So when the family died and the trust was listed as the beneficiary, at that time, a check was drafted by Fidelity of the notification of their client passing away. A check was drafted to the trust and sent to the trustee. Well, as soon as that money leaves that IRA, it's taxable. And so somebody now is responsible for those taxes. That's a worst case scenario, but it could happen. That's where, in my line of work, I want to avoid anything that could happen. If there's a better strategy that's going to clean it up, that's the one I want to take care of. I want to eliminate that friction point. So yes, you can leave an IRA to a trust, but again, it's not advisable. Having your beneficiaries listed directly that makes generally more sense. And we don't have time to talk about it today, but there is a trust that we like to incorporate that's specific for IRA assets, has all the right language. And so for a lot of our families, the majority of their wealth is inside of IRAs. It's not inside of, brokerage accounts or different types of accounts. And so we use those a lot to make sure that, hey, there's still a trustee in place, the 10-year rules in place, and it's a much simpler process doing that. But again, don't have enough time to go into detail on those trusts. But again, these are all things that I want to make sure I'm planting seeds in your mind so that you say, hey, that sounds like me. I need to reach out to Daren or Aaron and the team just to kind of say, hey, I need an hour to go through my situation. And you tell me specifically what makes more sense.
Daren, that last question by Sandy is probably a little bit more in depth than what we want to go through today.
Okay. Yeah, let's keep going. We'll come back to these questions at the end if we have time to get to them. That would be great. And you guys are doing awesome. Thank you for the questions.
And Sandy, I'll
makes it
send
very
you
nice.
Daren's calendar now with a direct message. You can grab a time with him. Okay.
I'm going to put up on the screen. We're going to go through some life changes, Daren, with estate planning.
Absolutely. So when you are thinking about a trust, what most people think is when they get their documents put together, they say, check that off, I'm done. They put their hands up and just say, thank you. I don't have to ever worry about that again. Not the case. Okay. So I don't want you to go into this process and think, well, once I get this done, I'm done. There's always reasons to review and go back and make sure that your trust is in good order. So things that could impact that, your assets, say you receive an inheritance, let's say, you hit the lottery, you do something crazy happens, right? Where something good or bad within your assets, you sell a house, whatever it may be. Those are triggering events to say, hey, we need to go back and make sure the language is up to date now that things have changed. Marriages, deaths, there's outlaws and in-laws, or in-laws and outlaws, like we like to say. So marriages definitely affect things. One thing that while we're talking about marriage, something that all parents dread as a possibility when their kids start getting married is the possibility of divorce. Divorce is, one of those things that it's more common today than it used to be, but we know it's potentially it's out there, it's possible. So that's where good trust planning, you can protect from an ex-in-law by using a trust. And so making sure that there's language that allows for that protection is really important. Kids are born, grandkids are born. Today I just met with the family yesterday. Based off their assets today, they want to leave a certain percentage to the grandkids, but the grandkids are growing, right? They're more and more are coming, and they're at that stage. Making sure, like sometimes you might think, well, it's been 5 years, our accounts have grown. Now we can afford to maybe fund something specifically for the grandkids. One thing I hear a lot is, I'd like to help my grandkids with college costs. So they want to set up some kind of a sub trust within their documents that 5 years ago didn't make sense. Today it makes a lot of sense. How can we make sure that we're benefiting our grandkids for those types of things? If you move to a different state, move to a different place, need to update addresses, different things like that. And then legal changes. So things that are happening in the legal world or the tax world. Just last year, Indiana changed its rule against perpetuities. And that's a legal term that just means how long can the trust last when I'm gone? In Indiana, for years and years, it was 21 years that after you died, the trust had to be dissolved and completed, typically within 21 years. So for most families, that's plenty of time. That's about a generation that's impacted. And that's plenty of time for the assets that they have. For larger estates, that's not enough time. So Indiana last July, we're about a year into it now, they changed that rule from 21 years to 360 years. That's a long time. And so that's not going to affect most people, but it's a change that could make a big impact on somebody that has a trust that says, hey, now I have the ability to extend this trust for years and years and affect multiple generations. For those families that are in that situation, great. We see it a lot with farm ground too. I don't know if we have any farmers on the screen. I bet we do, or have some tie to farming. But I can tell you that farmers love land and they don't want the land to leave the family. They could care less about money as long as they have land. And I don't disagree necessarily with them. So what scares a lot of, our people that are in farming in general is that, hey, when I die, I don't want to die knowing that my land might go to somebody else that's not in my family. And so that rule against perpetuities really has given farmers the ability to potentially stretch that farm ground to remain in the family for generations, which is great. I love that. So these things happen. And so these are just some examples of, hey, when's it time to kind of go back and review the documents and make sure everything's up to date? Some things are pretty clear. You're going to know about the legal stuff. I don't expect you guys to be reading this stuff on a daily basis. So from that end, it's something that you having a good advisor or somebody that can reach out and say, hey, some things have changed. We need to get you back to the attorney and make these updates.
We're going to bounce through a couple of these slides, Daren, really quick.
Yeah.
Just because we're 12 minutes from the hour.
I get talking. I can't help myself.
Yeah.
Fires me
So
up talking about estate planning. That's right.
the couple that we're going to bounce through real quick, we're going to get to the documents that you need to avoid probate, and we'll talk through them just very basically. And that's likely going to wrap up the rest of the time that we have, and we can answer a couple questions at the end. So
yeah,
thank you for sharing all of your wisdom in a short amount of time. We've talked a lot about probate, trustee responsibilities. Do we need a will? Do we need a trust? So we'll actually talk specifically about some of these specific documents to make sure when you're doing legacy planning that you have these critical documents in place, one, to help provide peace of mind, two, to avoid probate, but three, to make sure there's really clear directives on how you want to be taken care of when you can no longer make decisions on your own. And so, Daren, I'll bounce that back to you.
Yeah. So will, durable power of attorney, healthcare power of attorney, medical directives, those four are things that you definitely need. Okay. So these are things that are state specific. So you want to make sure they're drafted in the state that you live in, where your primary residence is at. Those are all very important. But the power of attorney documents, the healthcare directives, that's stuff that's while you're alive, to make sure that somebody can help make decisions or help you with things while you're alive. They have no power when you're dead. The revocable trusts, I am on the page that I don't think anybody's going to hurt their estate plan by adding a revocable trust. It's not mandatory, but it is something that I would highly recommend that people consider for lots of reasons. But the trust and the will, if you have a revocable trust, one thing to make sure is that your will becomes what's called a pour-over will, and it's essentially a backstop that says, hey, anything that should have been in my trust before I died that I didn't get there, you direct your executor to work with your trustee to make sure that those assets land in your trust so that nothing goes through probate. The beneficiary designations, transfer on death deeds, payable on death, that stuff is also stuff that you always want to make sure that you're keeping up to date on the accounts that qualify. Again, births, deaths, different things that come up. You want to just make sure that those are always up to date. So one of the valuable things about working with an advisor at Financial Enhancement Group, every year we meet, we go through these things. We lay them out, we review them, make sure everything's good to go. So that's a part of your annual review, is not just talking finance. Well, let's dig into the estate plan, make sure everything's up to date and everything's good. Again, found a meeting yesterday, one of my families. We updated some beneficiaries last year. On quick glance, everything looked good. When we looked at it, we noticed that on one of the designations, one of the names was missing a letter. And we fixed it immediately when we found it. But that's why those little things are important, just to make sure that all those things are always up to date.
Hey, one other real piece there, Daren, too, is, as you mentioned, it's even checking like old accounts.
Yes.
A lot of times we'll come across the 401k plan that may have an ex-spouse listed as the beneficiary, or there's a deceased person that's still listed as a beneficiary. That is critical in making sure that your estate plan is in line. One other point, and then I'll turn it back to you, is there's a big difference between a will and a beneficiary designation. So you may have a will which lays out your last wishes, and in that will, you're leaving Aaron, because I'm such a wonderful human being, your IRA. But your beneficiary on your IRA actually is leaving it to Daren, who's a better human being. So Aaron is in your will, Daren's your actual beneficiary on that IRA. That beneficiary designation will trump whatever your will says. So even if your will states that you're leaving this asset to a specific person, if your beneficiary is not changed in unison to what your wishes are, beneficiary designations will supersede what you have listed in your will.
Yeah, and it goes back that residual estate. I mean, if you have beneficiaries, that goes first in the order of operations. Those things take precedence. They trump everything. And so in your will, you could say all kinds of things in your will, but it has no power if there's nothing that lands there. It's not there. Typically, what I'd say wills are for, whether most valuable are for people like me or Aaron that have minor children, making sure you can name a guardian to who you want to have take care of your kids when you're gone, things like that are a trust can't do, that a will's required to do. But at our office, we want to make sure that anybody that comes into our office, a part of their plan is to avoid that probate process and make sure every document is in alignment. Like Aaron said, make sure that the right names are in the right places, and that everything is in alignment, because they're all kind of operating together. And so knowing that kind of stuff will make sure that things are in good order.
One other real quick nugget while we're here is this is a very often missed asset included in an estate plan, and that's a house. A lot of times houses will go through probate just because it's not added to the estate plan. So here in the state of Indiana, you can see on the screen on the bottom right, the transfer on death deeds. You can put a TOD on your house here in the state of Indiana. A lot of other states also add that. So if you don't have a trust which has the ownership of the house, it is vitally critical that you put a transfer on death deed on the home. That is an asset that's rather large that we traditionally will see go through that probate process because it's not properly planned for.
Yep, absolutely. Again, this stuff, we're talking very broad and giving very broad general things. But I can tell you no two of my families are the same. And there are reasons that in some meetings that I recommend not doing a transfer on death deed. Because let's say they have 5 kids and they want all 5 kids to have ownership of that house and nobody intends to live in that house. Well, now you're putting 5 joint tenants and common owners on a property. Yes, it avoids probate, but now all 5 kids have to agree what to do with the property. Yep. And if you get 4 of them to say, let's sell this thing, like, let's get it moving. And one says, I don't know, and starts to drag their feet. Now you can't sell the house because you don't have majority, of the people agreeing. That's where the trust would be much more valuable, because when in the trust, you could tell the kids what to do. You guys have first right of refusal to buy the house, and kind of lay that out if you want, or you just say, hey, liquidate the assets and distribute them to the kids. They don't want the house, and you just tell them what to do. Beneficiaries, and again, I'm guessing that you have been in this situation with your parents, a lot of you, or family. If you are in it for the right reason, you don't want to have to make decisions for your family. You want to be told what to do. I'm happy to carry it out, but I want to honor my parents and their wishes. And the more you lay out those things and take that decision off their plate, the better things go. They can be mad at you, but guess what? You're not here anymore to worry about it. You're with, you're in heaven and in a better place, and they can worry about it here. But if you tell them what to do, they're going to be more happy. That's generally the way it goes.
Just throwing up as we kind of wrap up, what are some practical next steps that we can leave the folks with?
Yeah, so look at your current situation. So everybody on the screen, you could be in different spots. You could have, like we had, the 11% that feel very prepared and the rest that kind of feel somewhat prepared for what they have. Just look at your current documents. How old are they? When's the last time that you got them out? Kind of read through them and see what, if you notice anything, kind of just do an evaluation. If you work with Financial Enhancement Group, get their documents to us so we can help you with that evaluation to make sure that, hey, let's look through this and make sure everything's in good order. So just doing that on a regular basis is really valuable. The second thing, Aaron, you can go ahead and go to the next, is how do you take action essentially to align what you currently want based off of your old documents. So if you're starting fresh, this is something you do automatically. You start to lay out all the questions that need to be answered, but then you go through and say, hey, what life changes have taken place? What different property, asset values have taken place? What new laws are in place? And work with somebody that can make sure that everything is up to date. The last thing is just to schedule these regular planning reviews and family discussions. Again, at Financial Enhancement Group, we do this annually at a minimum with our families. where this is a part of their annual meeting that they have, where we review everything and talk to the family and say, hey, is this still the case? Anything that stands out that needs to be updated so we can get you with the right person to make those changes. If you have documents from the 2000, like early 2000s, good chance you're going to need what's called a restatement to make updates to your documents, where you don't have to start from scratch. You just get a restatement of the original trust. That's the easiest thing to do. If you've had more current and there's just a few updates that you need to make, you're going to get what's called an amendment to the trust to just update those few provisions that need to be up to date now that things have changed. But again, it's something that you get it done, you're 95% of the way there, but the rest of your life, you're just thinking out over the next 5 years, does this still make sense? Does this still make sense? And making sure that you're doing that so that when the time comes that God calls you home, you can feel confident that, hey, I've got my affairs in order. I've kept up on this. I've made my changes. I've done what needed to be done to make sure that everything is going to go as smoothly as possible.
Tarna, are there any other questions in the chat that we need to briefly answer?
There's definitely some questions, but I think that they are a little bit deeper questions. Monique did say, thank you for today's presentation. Will we receive this slide deck via email? We'll send out the presentation to you, the recording of it. We'll also add it to our YouTube channel. We do have some of the other financial stewardship workshops that we have had this year on there as well. Daren, I'll go ahead and remove your spotlight here. But yes, they will be on our YouTube channel and sent out to you by email, most likely next week.
Wonderful. I'm going to throw up the last 2 slides here as we wrap up. If you do want to continue learning and reviewing our content, our next, as I mentioned, series will be August 21st. We'll talk about the investment side, and then the rest of what we do will be very tax focused at the end of the year, and that's where we can provide a ton of value with efficiency and making sure you have a proper tax plan moving into next year. If there was something that Daren talked about that sparked interest, I could see the chats today. There's a lot of good questions, very specific things that we can only talk in generalities on. If you want to have a conversation, please reach out to us, 800-928-4001. You can scan that QR code. We're very happy to have a more in-depth conversation regarding your specific situation, just because, as we talked about today, it was very general. We gave you a lot of information in a short amount of time. Estate planning is not a cookie cutter approach, one size fits all. There are a lot of moving pieces, and one of the most important things that you can do when you're setting up your estate plan is making sure you have a plan, and that plan is very well communicated to your successor trustee. It is highly important that you have the person that's going to help you through that process align with your wants and wishes. There's times where Daren and I have seen in our long careers to where someone doesn't even know they're named a successor trustee, and now they have an estate plan that they have a mess on, and they're trying to unwind very, very uncomfortable situations and uncomfortable conversations. So if you have your estate plan, if you're in one of those 11% that's already very well laid out, kudos to you. Make sure you're communicating that to your successor trustees. If you need help, that is what we're here for. So reach out to us, schedule a meeting, and we're more than happy to help you through any of your questions that you have. Tarna, Daren, anything you want to end with?
I'd just like to say, we love this stuff. It's stuff that everybody kind of knows is important, but they kind of put off. And if we can inspire you to come in, have a complimentary meeting to talk through these things. If you work with FEG already, to kind of elaborate on these things, we are very excited to help people. And anything that you guys have, please reach out, get a meeting on the books. We're happy to have a conversation to make sure that we are helping you any way that we can. And so to make you sleep a little bit better at night, knowing that everything's in good order.
Awesome. Thank you both for coming on today and sharing this topic with everybody. And just to reiterate what Daren said, one question could have such a domino effect on how things are laid out. Please don't hold those questions back. Get those questions answered tonight. or today. That way you aren't kept up tonight, as Daren was saying. But this presentation and the excitement that Daren and Aaron both have about this, Daren and Aaron, that is a good radio show. The excitement that they have about this is because of how many times they've been in front of a family where they didn't see these plans put in place. And they were the ones that were helping the family navigate some treacherous or unfamiliar water. And as I think what Daren said, and I think this will be the last one we leave you on, is your beneficiaries and your children want a plan. And if that plan is there, they will honor you in doing that. And of course, a confused person has a really hard time taking action. So thank you all for being here with us today. We can't wait to see you again next month. We will share the replay. And if you, I know Monique, you had asked for the slides that we didn't cover today. I will send those to you as soon as I get approval on them. And we will send out the replay on our YouTube channel and by email for you all next week. Thanks again. Bye.
Thank you, everyone.
Thanks, guys.
Great job.
Thank you.
Thank you.